Yes, I salute you all. Thank you for listening and thanks for watching. So basically today we are under family law 2, and the topic that we are going to look at, we are looking at the capacity to make a will, or capacity in formulating a will, or capacity in making what? A will. So basically under the law of what? Succession. Basically capacity to make a will, it is this actually the whole of it is provided under section 29 of the Succession Act. And capacity will look at two things. First of all, we look at the age. When you read subsection 1 of section 21, 29, provides that a person must not be a minor. A minor, basically, we imply that must not be a child, must be a person of 18 years and above. Then second, we look at sound disposing mind. Sound disposing mind, in this essence, we look still under Article 29, subsection 5, whereby it provides that this act removes capacity from any person whose mind is in such a state, whether arising from drunkenness, illness, or any other cause that renders a person not to understand what he or she is doing at that particular time or moment. You get? So we have a case of Banks versus Goodfellow. The case of Banks versus Goodfellow brings out four elements that it actually gives guidelines of what amounts to soundness of the mind. First of all, the testator must understand the nature and the effect of the business in which he or she is engaged. First of all. Secondly, the testator must be able to recollect the property he means to dispose of. Thirdly, the testator must be in position to recollect the persons who are the objects of his bounty. The persons those are the people that he intends to give property to. You get? Fourthly, the testator must not be suffering from any disease of mind or insane delusion, which operates to distort or distract his mind. Basically, note that in what? In mind. And generally, that is what was provided in the case of Banks versus Goodfellow. So when you move ahead or when you move front, realize that the court itself, in the layman, it does not insist that the testator must exhibit a high level of soundness of mind before he is competent to make a will. But however, when you read section 29, subsection 4, it provides that a person who is ordinarily insane may make a will during an interval which he or she is of sound mind. And this is known as the lucid interval. Lucid, lucid interval. And therefore, under this situation, the court presumes that the testator is of sound disposing mind. You get? And they follow the circumstances in each particular case. And circumstances in this particular case, the court presumes that that testator must make a will that is simple and straightforward. Where the will is made in a complicated, or where a will is complex, or where the will is technical, basically the situation is different. You get? For example, if someone is writing, maybe over, there may be some, I don't know, but for example, in primary, if someone is writing, I love, when we are vibing girls, we could say that I will love you until Lake Victoria dries. Because it was in our capacity, it was straightforward. But as per this age of mine, if someone realizes that I've wrote that I'll write, I love you until Lake Victoria dries, the first question that comes in mind, this is childish. You get? And many people that know me will say, this cannot be Simon, this cannot be Matalo. Matalo cannot articulate such a thing in this manner. Because actually the quotation is, what I'm trying to put on table is that someone that is is ordinarily insane but in particular intervals is sane or is of sound mind, the court presumes that such a person is intended to make a will that is straight and simple. But if you make a complex and complicated will, then the court will say, it is not him, it is someone else. You get? So when you read the case of Repak's estate, under this case, the testator, who was a widower, made the will in favor of his closest relative. You get? Then afterwards he was struck, and afterwards he was incapable to look after himself. Then afterwards he went through periods of his mind whereby he became a lot of confused. So in a short while after, he got married. When he got married, in the morning he made a will. He got married in the morning, made a complicated and a technical will in the afternoon. You get? In the afternoon. Then afterwards, in the night he died. You get? In the night he died. Then court held that while accepting the authenticity of this will, the deceased didn't have capacity to make such a will. The deceased had capacity to make a simple will, but not a complicated will. So the will was not considered. You get? So note that in mind. Then similarly, we are going to look at the rule in Paraka versus Felgate. Paraka versus Felgate. Under the case of Paraka versus the rule that was provided here, it provided that the effect to this rule is where a testator, while being of sound mind, instructs his or her solicitor to prepare his will, but is no longer of sound mind when executing it. This does not render or does not invalidate the will. The rule under Paraka, it provided that someone can instruct someone to make a will on his behalf, and the person executes a will, and court does not look at the fact that whether you don't remember what you intended to, you don't remember the will, so long as by the time of executing you had the knowledge and you instructed. But ever court held two things that must be proven under this rule. First of all, it was duly prepared in accordance with the instructions of the testator. Secondly, at the time of executing the will, the testator was able to understand that he was executing a will prepared pursuant to his instructions. You get? That is the knowledge, even if he no longer remembered it at that matrimonial time, but so long as he was the one who gave instructions. But even if he never remembered it, with what instructions he gave and the true dispositions that were portrayed in the will, so that is immaterial, even if he never remembered. But what they look at is they basically had the intentions in this essence. Then what they say that the testator may have capacity to make a will, but the will is nevertheless invalid, because if it fails to present the testator's true intentions because of two things: absence of free will, that's the first, absence of free will. Secondly, there was no knowledge and approval of the testator's part. You get? Those are the two things. So basically note that in mind. And here what we are looking at, or what we are trying to put on table, is that we are going to look at the two elements, that is knowledge and approval of the testator and absence of of free will. Knowledge and approval of the testator. This must be proved that the will was made by another party other than the testator themselves and signed by them later. Having knowledge is having the facts or the elements or the facts that are in the will. Approving is like in the form of a signature. You have approved. You get? For example, when you read the case of Clary versus Clary, Cleare, Clare versus Clare. When you read this case, it provided that the onus of proving that the testator at the material time when the will was being signed, drafted, had knowledge and subsequently approved, it is on the party who lies on the above or who lies on propounding the will. So note that in mind. You get. And also the presumption, it is presumed that the person approves and acknowledges when he is of a sound mind. That is the presumption, and it is rebuttable. It is a rebuttable presumption that it is the fact where evidence suggests that the testator was of sound mind, then they are presumed to have known and approved to the will. Unlike where the testator was of unsound mind. But however, this presumption will not apply on the following grounds. You get. First of all, the circumstances surrounding the execution of the will are such in the nature that cause suspicion. Suspicion, it may be whereby a beneficiary is the witness, or something like that. A beneficiary is the witness, or the beneficiary is the one that prepared it. You get. Remember, we are under the rule of Paraka versus Flygate. You get. So that is one. Secondly, where there is mistake in a will on its execution. Thirdly, where the testator was dumb, blind, or illiterate. You get. So that presumption cannot be taken in place, or it cannot be what? Considered. You get. So we are going to look at the most common situation that raises suspicion. We start with suspicion. Suspicion, this deals whereby it was the beneficiary that prepared the will. To bring a suspicion, there's suspicion. You get. If actually you say that a person can prepare a will on behalf of the testator, why is it the beneficiary? There's a possibility that the beneficiary wrote the will in his favor. The good case, we have the case of Hart versus Dumps. D-A-B-B-S. Hart. H-A-R-T. Hart versus Dumps. Under this case, the claimant was the son of the testator's friend, and the principal and the principal beneficiary under the testator's disputed will. You get. Another thing, the will had been prepared by a friend of the claimant, and the persons who had acted as witnesses had done it on the request of the claimant, rather than the what? The testator. Even the people that would witness that will had done it at the request of the what? Of the claimant, but not the testator. So it brought certain suspicions on the will. You get. So at the end of the day, court, however, held that the claimant had discharged this burden by proving that the instructions for the will had emanated from the testator, who was fully aware of its contents. So remember, under the case of Clare versus Clare, we say that the onus is on the person that is propounding the what? The will, proving that the accused had knowledge and approved. You get. Then when you go previous, you see that it is also possible to impute knowledge and approval to the testator by showing, quote, that the will was read over and over to the testator. But however, such rule is void basically. You must prove that you read the will to the testator times and times and times and times. For example, in the case of Remorse, court held that, expressed the view that where there is evidence that a will was read to the testator times and times and times, it is evidence, and it is but however it is not conclusive in itself, but it is evidence that the deceased person or the testator had knowledge and approved to the what? To the will. Then we saw another element which does not make the rebuttable presumption that someone was of sound mind, and they presume that he approved and had knowledge. The second one is mistake. The second one is mistake. Mistake is, this element is portrayed or is seen under section 36. When you read 36, you get portrayed under 36. And under mistake, we have like two categories basically. First of all, you have mistake concerning the execution of the will. You get, you can execute another person's will. So it brings that element that there is doubt. So mistake. Execute. For example, in the case of goods of hunt, here we say person prepared the will or prepared the will for herself and her sister. You get. But however, by mistake, he drew separate wills, but by mistake, he executed the will that was prepared by her sister. You get, by her sister. So this meant that there was some technicality which was by mistake, and meant she could not properly be said to have known and approved the contents of the will she had executed. Reason being that she executed the will prepared by the what? By her sister. So that is one of it under mistake. Secondly, mistake concerning unintended inclusions and exclusions. You can tell someone to write letter A, instead he writes letter B. So those are unintended inclusions. You get, for example, in the case of Moril versus Moril, Morel, Moril versus Moril, the testator instructed his solicitor to draw a will leaving 400 shares in a company to another party. But however, this solicitor wrote 40 instead of 400. You get. So that is the mistake concerning unintended inclusions and what? And exclusions, basically. Note that in mind. So we saw, basically we saw with that circumstance, suspicion, we have seen mistake. Now we are going on dumb, blind, and illiterate testators. Basically, here what you have to bear in mind, or what you have to put in mind, under section 29, subsection 3, provides that the capacity of a deaf, blind, and dumb testator to make wills, that they should be able to know what they should be able to know what making a will means to them. That's the general rule there. They must be in that position. And the good, actually, also you can even highlight on the Illiterates Protection Act. However much they changed the capped, but formally it was section 3. I don't know whether when they revised that act it changed, but formally it was section 3, which says that where enjoys any person who writes a document for his or her on the request of such person of that character, the document must address his full instructions or what he intends to do. Also read the case of Kasala. Kasala Growers Cooperative Society versus Kakoza and another. That is a good case on dumb, blind, and illiterate persons. Then similarly you have in the case of goods of seal, in goods of seal, S-E-A-L-E, goods of gill, G-E-A-L-E. Under this case, in the goods of gill, under this case, it was an example of a situation where a testator was dumb, illiterate, but however, to be able to converse into an intelligible manner with friends and family, and evidence before court suggested that he actually was a kind of intelligent, and it showed that they read the will times and times to him so that he can understand what he or she is approving and to have knowledge of that particular will. You get. So basically those are the elements that removes the presumption, the repeatable presumption that a person is presumed to have knowledge and approve the will once he's of a sound mind. But those are the exemptions. Suspicion, the circumstances, for example, beneficiary being preparing, mistake, dumb, blind, and illiterate persons. You get. So basically, another one which we shall end to, absence of free will. You get, absence of free will. Absence of free will, basically we saw it. Basically absence of free will, what we are talking about under absence of free will, we saw it whereby under the sound disposing mind, realize that a person must be of sound, must have that capacity, something like that. And what we saw here, or what we intended to show, is that under the rule of Paraka versus Flaget, it provided that there must be knowledge and approval. Secondly, there must be free will to the party. You get, where there is absence of free will, it will render the will invalid. This is provided under section 36 of the Succession Act, whereby if a will is done under undue influence, duress, coercion, mistake of fact, among some other illegalities, the will is regarded as void. It is void ab initio. You get? We have a good case of Hall versus Hall, Hall. Hall versus Hall. The testator made a will out of violence and threats from his wife. You get? Court rejected the will since there was absence of free will. You get? So basically note that in what? In mind. So that's the brief or the sum that I can talk about capacity in formulating a will, capacity to make a will. So that is the field that I can talk about, capacity to make a will. Other than that, thank you for listening and thank you for watching. Stay blessed and good luck.